We can move into the First Amendment. So if you don't have your pocket constitutions on you, we do have a copy of it here on the slide. So we fit a lot of protections into this very short sentence. We have the right to religion, the freedom of speech, and the press, and the freedom to assemble. So what we're going to be talking about specifically today is that freedom of speech, of course, as it relates to school employees and students. So we can move on to the next slide. With that, as we're going to talk about, public schools are governmental actors, and they do need to protect and respect individuals' free speech protections. But because of the unique situations and the context of a public school district, there are times when you can and must regulate that speech. So it's really going to be the overarching discussion that we have today. Additionally, we are going to talk about a few specific Michigan laws that govern political speech during an election season. This is the Michigan Campaign Finance Act and the Political Activities by Public Employees Act. We'll touch on the revised school code, and then of course the plethora of cases that interpret the First Amendment, because as you saw, that is a very brief statement, so it's been elaborated upon for many, many years. So first we have here is the Michigan Campaign Finance Act. I'll admit it's a lot less flashy than the First Amendment discussion we're going to have today. So generally, the Campaign Finance Act regulates your political activity. We talk about campaign financing, disclosures, advertising. There's a lot to it. Specific to Michigan school districts, we have Section 57. So this governs the activities of public bodies, such as schools, elected and appointed officials. We're talking your board members, your superintendents, and then also individuals acting for or employed by public bodies. So that's what we're going to talk about: teachers, staff, any like contracted agents. And it applies when you're supporting or opposing a candidate or a ballot question. So candidates applies to both local, state, and federal candidates. And ballot questions is when we're talking about, say, if your school has a millage or a bond proposal on the ballot. Generally, what Section 57 prohibits is using public money or resources for advocacy. And we're going to discuss exactly what that means and what that looks like. So we can go on to the next slide. So talking about the Campaign Finance Act, it is very heavily bureaucratic. So the Michigan Secretary of State is who's responsible for interpreting, applying, and enforcing the Campaign Finance Act. Specifically, you can obtain declaratory rulings, interpretive statements, different things to get an idea of the Secretary of State's interpretation of what the law requires and what it prohibits. There is also a complaint process. So if you go on their website, you can see all of the resolved complaints from the last 20, 30 years. It goes back pretty far. And so what an individual can do is usually you'll see a community member who does see some kind of campaign finance violation. They'll report it to the Secretary of State. The Secretary of State will investigate it, and you'll go through an entire process to see if a Campaign Finance Act violation did actually occur. So the penalties for a knowing violation include imprisonment of not more than 1 year, a fine of not more than $1,000 or both. And if it's not an individual, so this is where we need to be concerned about your schools, a fine of not more than $20,000 or equal to the amount of the improper contribution or expenditure. Luckily, the Secretary of State also sometimes just does formal warning letters, so you do get an idea that maybe a violation occurred, but you have time to resolve it and fix it. So with that, we can go on to the next slide. So the Campaign Finance Act, Section 57, as I said, is really what we're concerned about during this election season with schools. So what does it say? It says that you cannot use public resources to make a contribution or expenditure. We're going to touch on exactly what a contribution and expenditure is. However, the public resources you can't use isn't just money. I think most people think about you can't donate public funds to a candidate or a campaign, but this also includes other resources as well. We're talking personnel and their time, office space and property, computer hardware or software. Think of things like your email addresses, your school website, stationery and postage, vehicles, equipment and supplies, and volunteer services. So just the biggest point we want to touch on here is that your public resources isn't just funds or money. You need to be thinking about other ways you might be engaging in that advocacy prohibition. Okay, we can go to the next. So what is an expenditure? This is a very long list. We're just going to go through it really quickly. So it includes a payment, donation, loan, promise of payment of money, or anything of ascertainable monetary value. It includes goods, materials, services, or facilities that are assisting or opposing a candidate or a bond proposal, other kind of ballot question. Something that the Secretary of State has offered is that the Michigan Campaign Finance Act only involves references to a candidate or a ballot question by name or clear inference. So I know that there are a lot of issues we might consider political now, but we're really only for campaign finance purposes considering people who are on the ballot or questions on the ballot. So now what is a contribution? It's a payment, gift, subscription, assessment. It includes an expenditure, which we just defined, and all kinds of other things of ascertainable monetary value. The key that we want to talk about here is that that money has to be given for the purpose of influencing a candidate or a ballot question on the ballot. So that's where we get into this advocacy standard, and we can go to the next slide. So purpose of influencing. The Secretary of State defines the term influencing by using an express advocacy standard. So what we're looking for to be a Campaign Finance Act violation is any kind of public resources being used to get people to support or oppose a candidate or ballot question. The Secretary of State's been very helpful in giving us some magic words that we can consider that you need to avoid. They are very bad. You don't want to have anything printed or posted that specifically use the terms vote for or against, elect or defeat, supporting a continuation of, voting yes, voting no. Again, some of these are more specific to bond campaigns, but I think they also apply when we're talking about candidates. So we can go to the next slide. Fortunately, while we have this really broad prohibition on using public funds or resources for these purposes, there are some specifically permitted activities that are allowed under the Campaign Finance Act. The first is the expression of views by elected or appointed officials with policy-making responsibilities. This generally applies to your board members who have the ability to make policies. It might apply to your superintendent depending on job description, board policies, past practices. But really what it's saying is that even in that official capacity, you're able to express your views because it affects the school districts. But still, you cannot use district phones, stationery, computers, or other public resources to disseminate these personal views. And we're going to talk specifically about employees shortly. So next, other permitted activities are producing or disseminating factual information with issues that are relevant to the public body. So you're going to see this a lot with bond campaign materials. You aren't allowed to be engaging in advocacy. That's what your Vote Yes group is for, who's unrelated to the district. But that doesn't mean you can't show compelling, persuasive information that isn't express advocacy. So for example, we can't say something like, the roof is caving in, it's terrible, you need to support this bond. What you could do is say something along the lines of, the middle school roof was replaced in 1990. Studies from our architects show that it's exceeded its useful life and could, cause the building to deteriorate. Things like that would be acceptable because they're factual and can be verified. Something that will probably come up for you guys this year is the production or dissemination of debates, interviews, commentary, or other information. Generally, you are allowed to do in a regularly published document, say you have something like a school newspaper or newsletter, you're able to provide things like debates or interviews. The only thing is that you do want to be careful to ensure first that this is a regularly published document, not something specific to the election. And you still want to avoid engaging in that express advocacy. The Secretary of State had an issue recently in one of the school districts where a group of civic students did an interview with a local individual. I think he was an EMT. And at the end of the interview, the civic student said, do you have any more questions? And he told them to vote yes on a non-school related millage. This led to a complaint. The Secretary of State did investigate, and there was only a formal warning. But the opinion was that because the statement was outside of the interview, it wasn't related to a question expressly asked, and it was very clear advocacy. Again, they use those magic words we don't use, which were vote yes. that it could have been a violation. So you are able to have those debates, interviews, but just be aware of avoiding any of those magic words because you are using school resources to publish those newspapers. Finally, is use of a public facility. You may receive requests for people to hold candidate forums or different issues in your facilities. And what the Campaign Finance Act says is that they need to have an equal opportunity for use. So we can go on to the next slide because I think this one warrants a little more discussion. So when you receive a request to use your district facilities, first you need to check your board policies and your facility usage guidelines. So some of these say that we do not open it up to non-student groups, only student groups can use our facilities. So be sure to look at that to see if you can even open it up to these outside groups. If you have, then you need to consider your past practices. So say your district is more Democratic leaning, so you'd like to have a Democratic candidate come in. That would be okay, but you just need to be aware that once you open the doors to one group, you need to allow other individuals in. So a Republican candidate would also need to be allowed to be let in to avoid any kind of viewpoint discrimination. So as I have here, the key is to have equal access. If you have any kind of fee, make sure you're being consistent. And generally under the Campaign Finance Act, any kind of posting of posters, political brochures is prohibited. So just be aware of that as well. Okay, now I'm ready. So now payroll deductions. This is one of those things I said we need to be aware of the legislature modifying everything because previously there was a Michigan Supreme Court case in 2011, and then the Campaign Finance Act was amended to prohibit using any kind of public resources to do payroll deductions for PAC contributions. That was changed in 2023 under Public Act 244. So now you are allowed to use public resources to establish and administer those payroll deductions. Just be aware that it does require an employee's affirmative consent and it does need to be bargained, but that is one of our more recent changes. So then now the heart of what we're discussing today is the Campaign Finance Act and school employees expression. It might seem like there is a bit of tension between the Campaign Finance Act and the First Amendment, but the Campaign Finance Act makes really clear that it is not intended to squash the constitutional right of free speech to public employees. The key is that we want to make sure that because these are taxpayer dollars and individuals are the ones voting, that you can't use public resources to influence the election. So the Campaign Finance Act does specifically allow public officials or employees to express their personal views, use personal funds, and volunteer, but you can't be acting for the public body or engaging during personal time. So we need to think about if you're using your school email address, if you're posting things on the website or Facebook page. We need to think about, printing things for other people or using postage and making sure that we're not engaging in these activities during work time. So we can move on to the next slide. And not only is there the Campaign Finance Act to think about, there is an act very aptly named Political Activities by Public Employees Act. It makes very clear that public employees can engage in political activities. It talks about being a delegate to convention, running for different offices. But the key again here is that you can engage in these activities during hours when the person is being compensated for performance as a public employee. So just in summary on the next slide, we have here that when you're on the clock or on the job, employees generally cannot express their advocacy views, wearing t-shirts. Again, for Campaign Finance Act, we're talking about specific candidates or ballot questions, buttons or signs in class. We should not be engaging in those during school hours. Providing advocacy services. Again, you shouldn't be making political calls from your office phone or doing printing for a Vote Yes group or other things from the school district offices. We do have that board member and superintendent in some cases exception. And the main key is if you're on your own time or your own dime, employees may advocate and create advocacy materials. Nina, did you raise your hand?
Yeah, I did, Mackenzie. I just wanted to clarify something because I know a lot of educators tend to promote voting in general. So I just want to make sure it would be appropriate for them to wear a vote shirt or just something that says, exercise your rights.
Yeah, absolutely. So anything that's neutral is typically allowed. So yes, you can tell people to go vote. You can remind them when election day is, even when we're talking about classroom discussions. Definitely acceptable if you're just kind of being neutral and promoting that conversation, promoting voting, that's totally acceptable. Okay, well, if there are no other questions, I will now give the floor to Kathleen.
Okay, thank you, Mackenzie. Sadly, I now have to move us into something that is, in fact, very interesting, but not the nice cut and dry, you can, you can't, that Mackenzie was just talking about. And I'm a big fan of bright line rules, but they don't exist much in the world of First Amendment. So first of all, if you look at the number of, I don't know if you can see the number of slides, but there are a lot of slides, many of which I'm going to skip right over, but I want you to have the information. I really want to make this as useful for you in your day-to-day life as possible. So if you have questions, please raise those and we can talk through them. So let's start with employees. I'm going to look at both how can a school district regulate employee speech and how can a school district regulate student speech. But let's start with employees. This is a funny little cartoon. Should we talk politics? And hopefully the answer is yes, we can all talk politics in a nice, civil way. But we know that doesn't always happen. So what are we talking about here? The First Amendment is a morass. You could spend your whole life just thinking about the First Amendment. But we're talking specifically here about if you are a public employee, which all public school district employees are, what political speech can you engage in? When might you, perhaps as a principal, be able to regulate that speech of your employees? When can you absolutely not? So here are some basic things to always keep in mind. If a person is speaking on a matter of public concern, which has been essentially identified as political, social, or other matters of public concern, then that speech is afforded the highest level of protection under the First Amendment. It is assumed to have high social value. I'm sure we can all debate whether that's always the case. But what it means is that we have a far lesser ability to regulate speech that is on an issue of public concern, such as politics, social, educational, things like that. So if you believe you need to regulate an employee's speech in some way, step one is to pause and think about whether or not you are going to violate their First Amendment rights. So, disciplining for public speech. We basically have, there are 4 cases on this slide. There's actually 1 or 2 additional cases now that kind of sets the framework for us when we're thinking about, can we discipline or regulate in some way a public employee's speech? So first we have to ask ourselves, did this person speak as a private citizen or a public employee as part of official duties? And that's the Garcetti case, and you'll see some slides on that. Just in a nutshell, your speech made as a private citizen is protected in many instances. Speech made as a public employee, part of official duties, is generally not protected. Was the speech an issue of private or public interest? If the answer is yes, it was a public interest, more likely to be protected. If the answer is it was a private interest, as in I disseminated a manifesto about the grievances I have with my public employer, that's going to be more likely to be private and less likely to be protected. Then we have to balance the public employee's right to speak on a matter with the employer's right to basically provide efficient government services. So that includes impact on workplace. It can include relations between employees. It can include, and there's language about, did the speech or does the speech undermine public trust in the government entity. So that's a balancing act, and those are always not easy to apply. And if you have disciplined an employee for speech, would that employee have been disciplined for other lawful reasons? And so that's going to play into whether or not there's liability for that discipline. All right, so this is kind of again, the framework of public employee speech cases. Pickering is the first one. These are all Supreme Court cases. That's why they're the Supremes. And you can see that there's a fairly long space between cases, but each one is building on the next. So the first is the Pickering case. That gives us a balancing test. The second is Connick, and that talks about the private-public issue. And if it's of private concern, it's less likely to be protected. Garcetti was a district attorney, assistant district attorney. And when he spoke, was he speaking as an official or was he speaking as a private citizen? And then Lindke is a brand new one, and it addresses social media. And I know that as principals, you've never had a single issue with Facebook pages. You've never had employees put things that you weren't comfortable with up. You've never been bombarded by parents, right? So the reality is we live in this social media world, and the court has taken on kind of what that is going to mean for us. So very quickly, I'm going to go through these. Pickering is a case in which this teacher was fired for a letter to the newspaper. So obviously very public speech. And what the court ultimately said is that, yes, the letter was critical, but it did not impede that teacher's performance of duties. Nor did it interfere with the regular operation of the school, and therefore Pickering should not have been discharged. He is a public employee. He had First Amendment rights to speak on matters of public interest or public concern. And so we talked about that balancing test already. Okay, Connick v. Myers, 1983 is the next one. In this case, the court looked at, is the speech of public concern rather than personal interest or private interest? And to figure that out, we have to look at the content, form, and context of the statement. There's a lot of discussion about the fact that part of the reason we have a First Amendment is so that citizens can criticize government. And who better to criticize a government entity than someone who works for that government entity? So there's a strong impulse to protect criticism. However, the key is that public concern piece. And so the court has said, if a person is just complaining about the way their principal treats them, it has nothing to do with public concern, they don't like the way they are being treated, we are much more likely to be able to regulate that speech because it's a personal interest speech. Now, I should have said this at the beginning. I'm going to stop here and say, this is First Amendment. We also have National Labor Relations Act, and we have all kinds of protections around collective bargaining. So again, that's just another layer. You might have an employee whose speech wouldn't necessarily be protected under the First Amendment, but whose speech is protected under the bargaining protections. So just be cautious of that. Okay, so if this employee's speech doesn't relate to a matter of political or social or community concern, then as an employer, we have a wide latitude to manage that speech, much like a private employer. Garcetti, this is the assistant, this was 2006, so much more recent. This is that assistant deputy DA that I was mentioning, and he was concerned about a search warrant. He felt that it hadn't been done properly, and he wound up ultimately testifying for the criminal defendant. That's a nightmare right there. He was demoted because of it. It was a disciplinary action. And he argued that he had, a free speech right to criticize the affidavit. And the court said, no, you don't have a First Amendment protection because your speech was pursuant to your official duties. So I think this is probably an area we don't get into very often, which is good. Your average, teacher or other employee of a school district is rarely going to be speaking pursuant to official duties, but a principal might be, certainly a superintendent might be. Okay, so how do we know if it's speech based on official duty or as a private citizen? Well, basically, are you speaking in a way that your job compels you, or about an issue that your job compels you to speak? Okay, now this one is kind of fun. I say that with tongue in cheek. This is actually a Michigan case. It came out of the Sixth Circuit, went up to the Supreme Court, and I believe it was in June that the court ruled. Could be wrong about that. This city manager had a personal Facebook page. He'd had it long before he became city manager. In fact, the court notes that he had created a Facebook page sometime before 2008. So he'd had it a long time, apparently was an active user of his Facebook personal page, lots of pictures of his kids and, things that he's doing and et cetera, et cetera. But when he became a city manager, he also changed that little, whatever it's called, facts about us, where he put in that he was the city manager of this Michigan city, and he started to also include some information about the city or to solicit opinion about things that the city either was considering doing or things like that. Okay, the problem is that he deleted comments that he didn't like. So he might post something and make a comment, and then if someone commented on his comment and disagreed, he might delete that. So the question becomes, now this is an interesting one, because here he's not the speaker who was being silenced, right? He's the government entity silencing speakers. And was he allowed to do that? And so what the court said was, when you're considering whether a public official's social media is government action, right? So is he taking government action when he took down people's comments? You look at whether the public official had actual authority to speak on the government's behalf and purported to exercise that authority when speaking on social media. So that's our test. Sorry, I guess I didn't include. Essentially, though, the court decided that no, he was not speaking in the course of his official duties. All I can say is, for about as long as I could remember, I've gotten calls about employees putting things on social media, whatever the social media is for that particular generation. And it's never easy, and we can't tell them that they can't post things. I mean, I had clients who would call and say, can't I make him or her take this down? And the answer is usually no. But what we would like is for them, everyone, including our employees, to use good sense, right? And so even if we can't take something down, we might be able to talk about why it's problematic. And then there are things that we can take down. So you will undoubtedly have to make some phone calls to central administration and see if you could get your school attorneys involved in decisions about whether or not to discipline someone for their speech. So these are actually much more interesting cases. That was the Supreme Court framework. Very interesting, have to have it, okay. These are actually much more interesting because these get down into the nitty gritty. And this Bennett is also a Sixth Circuit case. And Bennett, that fateful evening in 2016, we probably can all remember things going perhaps ways we didn't expect. And Bennett was posting on her Facebook the election evening of 2016, and she wrote this: "Thank God we have more American-loving rednecks. Red spread across all America, even," and of course we didn't write it, but you can imagine she did write the word, and Latinos voted for Trump too. Well, probably unsurprising to everyone except her, this created a huge disruption to the workplace. She was a 911 operator. So, I mean, before people even got into the office the next day, there were complaints to HR. It was a big deal. People saw it and were offended, and were also really surprised by it. Now, by midday, she took it down based on a conversation she had with a good friend of hers who told her that she was shocked that this had come from Bennett. So she did take it down, but it was too late. It was out there. People knew about it. People had screenshotted it, et cetera. So she gets fired for violating 3 policies, for the city or the county. And she sued for First Amendment retaliation. The Sixth Circuit said that her speech was not protected. The jury had found that it should have been, but the Sixth Circuit said, no, it's not, because so in this case, there was no argument about whether the speech was of public concern. It was politics. It was who won the presidential election. So what they were looking at is, did her interest as an employee in making comment about politics outweigh the employer's interest to an efficient workplace, public trust in the entity, et cetera. And and what the court here said was essentially yes, well, or no, I guess the way I phrased that. Her interest did not outweigh the employer's interest in an efficient workspace. Nobody doubted that if she came back, she was unapologetic, let's put it that way. She felt she was the victim and she should be apologized to. And so the court agreed that there was no way to bring her back without disrupting the workplace. But the details of all that show you just how down into the weeds courts get when they're talking about these cases. And so that's how down into the weeds we have to get. This is one of my personal favorites. This is from the Third Circuit, and it was 2015. I don't know if people still blog. Maybe they do. This particular teacher was blogging. It was a private, it was her personal blog. She didn't fully identify herself. She didn't identify her school, but people knew it was her. And she made some really derogatory comments about her students, among other things. I mean, she would post, recipes, things like that. But she did, and I took out one of the slides, but I wanted to give you some example of some of the things that she would post. So again, she did not identify students, but it was bad enough that people knew who she was and that she was talking about her students. So obviously not a great idea. She gets disciplined, she sues, and the Third Circuit found that her speech was not protected because it wasn't addressing an issue of public concern. Now, she maybe could have written a blog about the, increasing mental health issues and the difficulty getting kids to school and how much harder it has become to be a teacher or an administrator in a building, et cetera, et cetera. That would have been okay because it would have been a public concern. But the fact that these kids irritated her was not a matter of public concern. Also, the school was obviously able to demonstrate substantial disruption because 200 parents requested that their child not be placed in her class. you really can't get more disrupted than that. They had to hire an additional teacher to cover those students. So she lost that case. This is an Eighth Circuit case, 2024, which I'm sure it started many years earlier. It was a Black Lives Matter issue. Those of you who were around, which I'm sure you all were, during COVID, I had a lot of issues come up when teaching went home, learning went home, and the videos. And so I have a T in my background for Thrun, you can see that, but we had a lot of issues where, teachers had whatever their house had. I mean, it might have a Black Lives Matter flag or something else. And so we had a lot of discussion about what was appropriate and what wasn't. So in this particular case, teachers were displaying Black Lives Matter posters in their classrooms. That was no problem as far as the district was concerned. Then some school district residents asked that the district permit posters that had All Lives Matter and Blue Lives Matter. And as you know, that was a very contentious issue at that time. And the district said, no, we're not going to allow those posters to be placed. And the plaintiff sued under the First Amendment. And what the court said was, yes, it is private speech. So it's the teacher is not speaking for the government or whoever has the poster up. And the district, it was pretty clear, it should be clear to people that it was the teacher's speech, not the district's speech. Okay, so that's why it was private, not public, public official duties. However, because the district had created what's called a limited public forum, essentially they allowed private people to display posters, in this case, Black Lives Matter posters. They had created this limited public forum, and when they refused to let other viewpoints also be posted, they engaged in what's called viewpoint discrimination. So this ushered in a period of a lot of policies or discussions about enacting policies that said you can't have anything posted or things like that, because we don't want to engage in viewpoint discrimination. But the ACLU has challenged that, and honestly, probably the best way to go is to just allow things that aren't profane, vulgar, etc., but don't limit it to one side or another, or one issue or another. Okay, it does not want to go forward. There we go. So I'm not going to go through these. These are for your purposes if you're thinking about this later, but I tried to put together some basic flow charts of scenarios that might come up. Now, all of these are concerning a public employee. So a public employee engaged in non-political speech as a private citizen on a matter of public concern. There is some disruption, but that disruption does not outweigh the efficiency of public service. And so it is, does not outweigh so it's not protected, because that efficiency of public service in the balancing act weighs higher than what the person's interest in speaking is. So I kind of took you through several of those. As I said earlier, don't forget, in terms of collective bargaining, you want to look at that. Look at your employment contracts, look at your board policies. All of those things may contain language that further protects speech, or makes it clear what speech can be regulated. Okay, let's talk about student speech. Again, I haven't heard much of it this year, but the past two election cycles, I certainly had a lot of calls from principals saying, I've got a kid who's wearing I had one a couple of kiddos were wearing flags, but they were Trump flags, so not US flags, but Trump flags, and it was causing a disruption. And could the principals make the child stop wearing that? And so we had to go through that. Frankly, by the time it got to me, it was already to the Attorney General. So, these are big issues. So let's talk about student speech, because it is different, right? There is a possibility that a public employee may be perceived as speaking on behalf of the government. And so that puts employees in a different realm. Very rarely is a student going to be perceived as speaking on behalf of the school district or the government. Also, we know we have an interest in maintaining a safe and productive learning environment. So we can regulate student speech if it is creating a substantial disruption or a material interference with the ability of the school to do what it does, the educational process. Or there is, and this is typical court speak, right? There is a more than unsubstantiated fear of disruption or interference. What does more than unsubstantiated mean? A little bit more than there's no substantive reason to fear this. I don't know. But essentially, we'd want to be able to show that perhaps similar speech in the past created a disruption. And so there's a more than unsubstantiated fear that the disruption will occur again. Or, this happened 2 school districts over a month ago and there was a disruption, things like that. Okay, so like with employee speech, we have several Supreme Court cases that have taken us through, over the years, an analysis of how strong or how great are students' First Amendment rights when they are speaking on the school campus. And then with that last one, Mahanoy, we go to off-campus speech. Tinker is the famous one. I'm sure you've all heard of it. I'm not going to necessarily talk about each one, but I did want to give you this great little table that shows kind of where each of these cases took us. So Tinker told us that students do not leave their First Amendment rights at the schoolhouse gate. They have First Amendment rights while they're students, while they're on campus, but a school can regulate that speech. In other words, suppress the First Amendment right if there is a substantial disruption. And this is where that substantial disruption and material interference language comes into play. Then we go on to Frazier, which is almost 20 years later, 1986, in which the court says it is pretty obvious that schools can prohibit, regulate, suppress First Amendment for speech that is vulgar, lewd, obscene, and plainly offensive, even if no substantial disruption occurs. I've relied on that a lot over the course of my career, right? There may not be a disruption because, I don't know, the group of kids who are aware of it, it doesn't faze them, but we can regulate that anyway. School, and then Hazelwood, just a couple of years later, actually addressed school-sponsored speech. So this was a school newspaper, and did the principal, I believe it was the principal, have the right to pull certain articles because it was school-sponsored speech. And the students, of course, felt that their First Amendment rights had been violated. The court said, no, if the speech restriction is reasonably related to legitimate pedagogical concerns, then the school can regulate the speech. And then Morris v. Frederick, that was 2007. you can stop people from promoting illegal drug use. So even if there isn't a substantial disruption, that's the bong hits for Jesus, which you might have heard of before. Okay, so I'm not going to go through this because we talked about it very quickly. Pretty this was the vulgarity one. Essentially, this young man did a speech in which he alluded to certain sexual situations. And then Hazelwood, we talked about that. Bong hits for Jesus. And there we say that, yep, principal can regulate speech that is promoting illegal drug use. Now, the question that has come up on occasion in the last few years is, what about, I mean, now bong hits, okay, marijuana use, if that's what we're talking about, is not illegal in a lot of places. So can we still regulate that speech? And our analysis, and I think this would bear out, is yes. For one thing, it is still illegal federally, right? So, and for another thing, it's not legal for minors to use. So yes, we get that question, but I would say you could still regulate this. Now, this one is the most recent, terribly, terribly interesting, I think. This has to do with off-campus speech. To what extent can site or central administration regulate off-campus speech? So this young lady was a rising sophomore. She didn't make the varsity cheer team. She's upset. She did a private snap to 250 of her closest friends, expressing her frustration, including, and I think I have a picture of it, flipping the camera off and using some profanities. She did it on a Saturday. She wasn't on campus. She was using her personal phone. She wasn't using campus Wi-Fi or anything like that. And the school disciplined her. The court said, yeah, you can kind of see it there. The court said, no, disciplining her for her off-campus speech violated her First Amendment rights. Okay, so that's our baseline. Disciplining for off-campus speech, in this case, violated her First Amendment rights. However, the court reminded us that there is off-campus speech that can be regulated. Okay, and we deal with this all the time, right? Something happens between students on a weekend, after school. My favorite is the parks next to the schools, the elementary schools, where they're in the park. And so off-campus conduct, including speech, comes to you all the time. And you have to figure out, can I or can I not discipline or take action? And the answer is that as a basic, baseline rule, no. However, if that speech is serious or severe bullying or harassment of particular students, then yes. If there is a failure to follow rules for computer use, online school activities, etc. So let's say it's off campus, it's on a weekend, but it's a group of kids who are online together doing a school project. Okay, so that's going to give us more authority to regulate. And if it is a breach of school security devices, including material banned from school computers. So as we know, a lot of kiddos do this off-campus non-school hours stuff on their school computer, and that's going to put things, that's going to change the analysis a little bit. Okay. So what the court said in this case is that for a school official to regulate off-campus speech that was not during school hours, etc., for expressing an opinion. Now, she didn't express it very gracefully, but she expressed that she disagreed with decisions that had been made about varsity cheer and I think something else, I don't know, softball or something. The school has to be able to show that there was a substantial disruption, not just that they are made uncomfortable by this unpleasant, unpopular viewpoint. I have over the years had a lot of calls. This teacher or this principal is being made fun of, is, this and that. And I absolutely understand the desire to punish students, but where it takes place completely off campus and it doesn't create a substantial disruption, we're not going to be able to regulate that. And sometimes it does create a substantial disruption, depending on what the teacher or administrator has been, accused of doing, things like that. But we have to be really careful about that. We do not have the long arm of the school does not get to reach out into non-school spaces and tell kids what they can say or not say, generally speaking. Okay, and I know we're almost out of time. So I'm going to skip through that. This is a Michigan case. I'm not going to go into it, but you can see why this might have been an issue. In this case, the court said, no, the school doesn't endorse this message and you can't ban that shirt, even though there were a lot of Arabic students in the district who might have been offended. And then this one, cocaine addict, et cetera, et cetera. Again, no disruption, so no ability to censor. And this is another Michigan case that's really recent. Let's go, Brandon. We all know what that means. Students were wearing this sweatshirt that said, let's go, Brandon. Everybody understood what that meant. The words themselves aren't, offensive, but everyone understood what it meant. And that it was meant to be offensive. And the court in this one actually said that it was because everyone understood what the phrase meant. This brought it under Frazier, which is the ability to regulate obscene, lewd, or vulgar language. I don't know. I don't know if that would withstand. If we look at this again, this is a Western District case, meaning it is the lowest federal level of law of court. So I'm not sure where this would go if it moved up the court system. Okay, that was a lot. So I'm sorry about that, but I'm happy to kind of discuss any questions.
No, that was a lot of great information. Thank you for presenting that. I don't see any questions in the Q&A, but if you have any questions, we'd love to have those at this time. I'm just curious for you, for the ladies, are you hearing from schools this year? Generally during a presidential election time is when we have more issues of free speech in our buildings. So I'm just curious if that's kind of the cycle again this year with the presidential election.
I'll start and then let Mackenzie jump in. I have not gotten the volume of, kid is wearing this sweatshirt or this t-shirt, can we make him stop? Or teacher is, in Arizona, we had a Red for Ed one year and it was a big deal. I haven't seen it this year. I don't know why. Mackenzie, what have you been seeing?
So in the campaign finance realm, we've got a lot of bond materials we have to review. The only, I guess, more exciting one is we had a community college client that one of the professors put a Donald Trump sign on his door with a superhero cape on, the hero we need. But that's the only instance I've heard of so far.
Oh, sounds good. I see a question came in. So Aaron is saying, I've not allowed students to hang political signs of any party in hallways, for example. Just want to make sure I'm doing what's right. I've asked students not to wear FJB shirts, but haven't said anything about other political apparel.
So this this feels like a little bit of a situation in flux, because really until a couple of years ago, I would have very firmly said, as long as you're not engaged in viewpoint discrimination, so you're not allowing any of the political parties, kids to hang signs for any political party, that you're fine. I still think that's the safest way to go. And so I guess could there be an argument that so long as you didn't ban one or the other, and it just so happened that these are the ones that got hung, would the ACLU come after us and say, hey, you're suppressing free speech? Yeah, they would. Would they succeed? And I'd rather be on the side of we did not engage in viewpoint discrimination, and we maintained a calm educational environment, because we all know how quickly things can ratchet up, especially if we have a community that is divided. So I think you're doing the right thing, but could it be challenged? Yes, and then we would just deal with it.
And
I would
Kathleen,
agree from the, oh, sorry, go ahead.
No, I'm sorry. I was just going to ask in terms of, the asking not to wear that specific, could that be tied back to district policy of, any shirts with profanity are not
Yeah.
allowed?
Absolutely. Yeah, I agree with that. I think that once in a great while, a court has ruled differently, but for the most part, courts have been very consistent in saying administrators can regulate vulgarity, profanity, lewdness in students' clothing or words. Mackenzie?
Oh, yeah, I was just going to say that under the Campaign Finance Act, it does have a prohibition on hanging political signs in government buildings. So I think you could also follow that. And I do know that certain school district board policies do prohibit like political advertisements. So that's something that you could also have in your back pocket as well.
Mm-hmm.
We have another question from Jeff. If your school is a polling place, what are the rules around poll watchers or protesters at a polling location?
I would have to look at the statute a little more closely, but generally it's within the 100 feet of a school zone. If you're outside of that 100 feet, then you are able to hand out literature. On election day, if you're a polling place, the election coordinator is essentially taking over the building. So it's their responsibility to control the actions that are occurring on that day.
All right. Not seeing any additional questions, I am going to wrap it up. We're at 10:02. Thank you, ladies, so much. This has been extremely helpful. I know that our members are taking away some great information. Thank you for the additional slides, because I think that is helpful for them to have that information. So again, we have recorded the slides, as well as the recording will be emailed out. This will also be posted to our webpage. I want to remind you all that we have continued sessions on our legal guidance. So our next session, was going to put the date up, but since we're over time, we will email that out to you, but just want to make sure that we're always here from you, MASSP, as well as with our partners. So again, thank you to Thrun Law Firm for partnering with us today on this session.
Our great pleasure. Thank you.
All right.
Thank you.
Thank you. Everyone have a great day.